All right, next on our docket is case number 24-148, Steak and Shake, Inc. versus Amber Nicole Spears and Eric Spears. Counsel, you prepared to?
Yes, sir.
All right, please proceed.
May it please the court, I'm Lindsay Lawton. I'm here on behalf of Steak and Shake, the appellant, and I would like to reserve 5 minutes for rebuttal.
Thank you.
Thank you. Your Honors, Steak and Shake is here today to ask that this court enforce the exclusivity bar of Section 440.11 through this appeal. Section 440.11 provides that an employer's liability for an injury to an employee under the workers' compensation law shall be exclusive and in place of all other liability. There are only two exceptions to this exclusivity bar. One is if the employer doesn't obtain workers' compensation insurance, and the other is for an intentional tort. Neither of those exceptions is at issue here. Section 440.11 provides no exception to this exclusivity bar for a purely psychological injury, which is what is at issue here. And so that means Steak and Shake is not liable in tort for the injury at issue here, and the trial court should have granted the motion for summary judgment. To overcome the effect of the statute, the appellee has relied on the conclusion that her injury is not compensable in the workers' compensation forum. That is not an exception to the exclusivity bar, and not a valid argument for two reasons. The first is she has not tested this assertion that her claim is not compensable in the workers' compensation forum by presenting a claim in that forum. The circuit court is not empowered to decide the compensability of a workplace injury through workers' compensation.
Well, does every
law.
claimant have to do that?
I'm sorry?
Does every claimant have to do that? Is it, I don't recall from my first DCA years whether they absolutely have to go into the workers' comp system and see if they have coverage there before they can bring a private lawsuit.
Well, our argument is that is basically the effect of the existence of the workers' compensation law and the exclusivity bar. Case law is replete with statements explaining that the workers' compensation law is the employee's exclusive remedy for the employer's
But if I'm the employee and I'm injured and I take the position that it was an intentional act, do I still have to go through the workers' comp system and get a ruling at some point that it is an intentional act, you need to be over in the state court litigating it, or can I just go to state court and file an action for intentional?
I think under that situation, you could go to circuit court because that is an express exception to the exclusivity bar. But since the exclusivity bar doesn't provide any exception for any other type of injury, then they have to go to the workers' compensation forum first.
So I think I am somewhat sympathetic to your argument about the text of the statute saying that it is exclusive and in place of all, let's bold that word, all other liability. I might also be sympathetic to the argument that courts should not be rewriting statutes. But I'm looking at the language in Aguilera, where the Supreme Court specifically seems to conflate in a binding way, compensability with applicability of the statute, the exclusivity portion, where it says, immunity extends only to, quote, an accidental injury or death arising out of work performed in the course and the scope of employment. So in other words, not everything, just those accidental injuries that happen in the scope of employment. If I then compare that to the language of 93, that a mental or nervous injury due to stress, fright, or excitement is not an injury by accident arising out of the employment, it seems we have not a precedential, but a statutory exclusion here. Can you walk me through why that analysis might be wrong?
Yes, thank you for that opportunity. So Section 440.093 is not about immunity. You have to read that section in the context of the entire chapter, and indeed in the context of other language within that section itself.
Well, specifically reading it in context of that language from Aguilera, which seems to now like I said, conflate in a binding way compensability with your immunity.
The case you're citing is, you say Aguilera? I don't believe we discussed that in the briefs, and so I'm not completely familiar with I'm not familiar with the facts of that case. The language that the court is using, though, that you're quoting, is reflective of Section 440.011, or .11. And I don't believe that the Aguilera case was addressing the specific issue we have here today.
To be clear, that case and the line of cases following it seem to be dealing with intentional torts primarily. But the reasoning and the express language used by the Supreme Court, it says liability is limited to, or I'm sorry, not liability, immunity extends only to. That gives me a lot of pause.
I understand that, but I would say we have the Aguilera language, but also we have language from the Florida Supreme Court in Ella versus Shova that says, under the Act, workers' compensation is the exclusive remedy available to an injured employee as to any negligence on the part of the employee's employer. And so while Aguilera may be using some other language when they're talking about intentional torts, we have language in Ella versus Shova saying when we're dealing with negligence, you have to go through the workers' compensation scheme. And we also have that same language in the First District case, McNair. It says, excluding exceptions not relevant here, Florida statutory workers' compensation scheme provides the exclusive remedy for an injured employee. Likewise, in this court's decision in Kent, it says the Florida legislature has created a comprehensive process for consideration of claims against employers relating to the on-the-job injuries sustained by their employees. So in this case, there's no dispute that the injury happened on the job. It arose in the course and scope of employment, just as a matter of objective fact. And I understand that.
As a matter of objective fact, yes, but as a matter of law, no. 093 specifically says that is not that thing.
And again, Your Honor, my response to that is that you have to look at 093 in the context of the whole chapter, and you have to consider the very next sentence after the one you're quoting, which says that benefits are not payable for this type of injury. And so the purpose of the statement saying that this is not an accident arising out of employment is not to say that this type of claim doesn't belong in the workers' compensation forum, but to say that when it gets there, there aren't benefits available. And that is because the legislature decided to apply in the workers' comp forum basically the traditional tort impact rule, which doesn't allow recovery for purely psychological injuries if you don't have an accompanying physical injury. Of course, in the current tort world, you can get that type of recovery from just a touching, basically. But under the workers' comp statute, you can't. And that was, as you know, the laws that existed in 1968 when the Florida Constitution, the current version, was enacted, and that is the law now. And if we allow the appellee to overcome sections 440.11 because she did not sustain a physical injury, that circumvents the workers' compensation scheme, and it leads to an absurd result. It means that someone who sustained a greater injury by, for example, having a heart attack during the robbery and also having psychological trauma would be limited to the benefits available through workers' compensation. But someone who only had the psychological injury could go to circuit court and get unlimited, potentially, recovery for the psychological injury. And
Well, I guess the heart attack would be a physical injury.
it would.
Okay. So if the robber comes in and says, everyone get back into the freezer in the back of the restaurant here, and holds a gun to their head, and that's not compensable because there's no injury, right?
That seems to be the case, but again,
Under the statute, under the workers' compensation system, sorry, even if the employer was entirely negligent and failing to have any training about these situations, failed to have any security in place, whatever, the legislature said tough luck. So they've kind of taken away that cause of action.
that's right,
Or-
but it's important to remember that cause of action didn't exist under traditional tort law either. There was traditionally a requirement that you have a physical injury, and the legislature has said that, even though in regular tort litigation, the courts are now allowing recovery for that type of injury without a physical injury. Workers' compensation isn't going to do that. And that is because the legislature decided that in exchange for the automatic payment of benefits for physical injuries, or even psychological injuries that are accompanied by physical injuries, the employees are giving up some rights.
Well, isn't there an independent cause of action here that the plaintiff has? I mean, isn't there an independent tort action the plaintiff has that has been given up under the workers' comp system? Haven't they given up access to courts, I mean, under the constitutional provision that seek redress for that particular claim? That's how I'm conceptualizing why they're here today, which is that they brought an independent tort claim for this type of injury that's not compensable under the workers' comp, but would be compensable under the tort system.
That's correct. It would be compensable potentially under the current tort system, or at least, we wouldn't be asking to dismiss it. Well, there were some arguments below about whether the current impact rule is met, but assuming that the current impact rule in tort litigation wouldn't be a bar to her suit.
I don't remember the Supreme Court case where the challenge under access to courts under the Florida Constitution. What they can take away. What can the legislature take away and force everyone into the workers' comp system and to ensure that it's still constitutional? I don't recall whether, can you take away a cause of action? You retain 99 causes of action, but one is taken away. Is access to courts been denied or not? I don't recall. Do you?
I do. There's a couple of answers to that. So the first, the legislature can take away a cause of action as long as there is a reasonable alternative through the workers' compensation system.
And here there's not. In this particular case, there's not.
Her argument is that there isn't one, but that theory hasn't been tested through the workers' compensation system.
Okay.
But additionally, it's important to remember that if the cause of action that you're asserting is being taken away did not exist for you in 1968, then there's no access to courts problem. And that's the situation we have here, because in 1968, the tort impact rule was the same as the statutory impact rule for workers' compensation. If you have no physical injury under that traditional rule, you can't get a recovery for a psychological injury. And so, yeah, I understand that it's unfortunate, certainly terrible what happened to Ms. Spears, but her remedy is simply just not from Steak and Shake through a tort action, because that's what the legislature decided. And again, I would just point you back to multiple cases, including Ella, McNair, Kent, saying that when you're talking about negligence as opposed to intentional torts, the employee's remedy for an injury is through the workers' compensation system. And Kent explains that just because the employer would have a substantive defense within the workers' compensation forum, meaning that the employee can't get benefits, doesn't mean the courthouse doors are open. It means there's a substantive law saying that under the legislature's judgment, benefits aren't payable in this situation. And that's exactly what we have here.
If the intruder here had, or the robber or whatever, if he touched her, if he'd scratched her, requiring a Band-Aid, would that have fallen under the statute? And you'd have to provide compensation?
Are you asking if that would she be entitled to benefits under the workers' compensation system?
Yeah, because physical injury requiring medical treatment. You have to have an accompanied physical injury requiring medical treatment.
So that would be a question that only a JCC or a carrier could answer, because
That's, okay.
and I'm saying that partly because I can argue maybe it wouldn't, because that's not. There would be a question about, is that medical attention? Is that medical treatment a
So some
Band-Aid?
carriers would define that as medical treatment and others wouldn't. A Band-Aid.
Maybe so, and if that happened, then the claimant could take the dispute to the JCC. And the JCC could say, is that an injury requiring medical treatment or not? If the claimant didn't like the answer, the claimant could then appeal it to the First District Court of Appeal. But what the claimant can't do is skip that whole process and ask the circuit court to decide that, because that determination is within the exclusive subject matter jurisdiction of the JCC and then the First DCA on appeal. And so what we're asking today is simply that the court enforce Section 440.11 and abide by all the case law from this court and the Florida Supreme Court, saying that when there's an injury caused by negligence, that injury has to be litigated in the workers' compensation forum. If it is an employee's injury and the employee is trying to get compensation from the employer. And if there are no further questions, I will save the rest of my time for rebuttal.
All right, thank you.
Thank you.
Good morning, Your Honors, or afternoon now, 12 exactly. I'm Jack Hamilton. Sitting with me is Madison Cacciatore. We are with the Melbourne law firm of Nance Cacciatore. We represent the appellee in the case, which are the appellees, Amber Spears and her husband, Eric. The Florida Constitution allows redress under Article 1, Section 21. The court shall be open to every person for redress for any injury, and justice shall be administered without sale, deny, or delay. Florida Statute 2.01 basically says that the common law and the statutes of England are part now of the laws of Florida, and they adopt basically the common law of Florida. The Willis case is the Supreme Court case, which is exactly on point in our case. The facts are virtually identical, except that she wasn't an employee, but there was a touching of her during this robbery. A gun was put to her head, and she filed a claim for negligent
Well,
infliction
then
of
it
emotional
wouldn't be exactly like your case then, because it's not dealing with the workers' compensation statute at all.
It's not dealing with workman's comp, but it basically confirms the common law remedy of negligent infliction of emotional distress as part of the common law of the state of Florida. So this is a constitutionally protected cause of action that our client has filed, and the defense is simply that they're immune from suit because it's workers' comp. It's not workers' comp. The statute, and we've talked about it already here this morning, but 440.093 couldn't be any more explicit. A mental or nervous injury due to stress, fright, or excitement only is not an injury by accident arising out of employment. And then in the last sentence, a physical injury resulting from mental or nervous injuries unaccompanied by physical trauma requiring medical treatment shall not be compensable under this chapter. This is not a workman's compensation case. It falls outside of the workman's
So
compensation case.
let me ask you this. 440.11 does say all other liability. We do know that that has been somewhat narrowed by the Supreme Court, but it seems to me that that narrowing has been in the nature of intentional torts. If we were to follow your argument here that the combination of the Supreme Court saying all doesn't mean all, with 440.093, would we be expanding the exceptions that have been laid out by the Supreme Court beyond intentional torts?
Well, I think the statute itself says very specifically. I mean, it's not just an exception to workman's comp. A mental or nervous injury without physical injury requiring medical treatment is not even included in workman's comp, specifically according to 093.
Well, you miss an intermediate step there, because like I said, 440.11 only deals with the immunity provision, the exclusivity provision.
Right.
For us to say that exclusivity is the same as compensability requires that extra step of looking at the Supreme Court's opinions that say this only, your immunity only applies here, because the statute itself says immunity applies in all cases of liability.
Well, but I think it has to be interpreted in terms of just common sense. I mean, there's no situation that I'm aware of where you can deny somebody a constitutionally protected cause of action without giving something in return. And in my brief, I cited, the no-fault law.
And that may be very well the case, but in that case, would not the correct challenge be to 440.093 saying, well, this is unconstitutional, rather than saying the entire workers' compensation immunity system is unconstitutional? And since we haven't done that, are we kind of putting the cart before the horse?
I really don't understand really what you're saying, Your Honor.
Well, we would be presuming the unconstitutionality of 44093 there, when that hasn't been challenged and that hasn't been determined.
Well, I'm not presuming that it's unconstitutional. I'm presuming that it is constitutional and that it says and the words are what they are.
For us to say that there would be no remedy available, and that would be unconstitutional because there is no remedy available, would be for us to, sorry, I'm kind of circling around myself at this point, would be for us to say that the challenge should be to the immunity provision because it does not provide access to the courts, rather than the challenge would be to 44093, saying here is where that prohibition lies.
Well, I think statutes have to be read, in conjunction with each other. And I think, the Workman's Comp, Chapter 440, which encompasses 44011 as well as 44093, have to be read, there's a Latin term for it, but in conjunction with each other. And when you do, it's very clear that the injury suffered by Amber Spears is not a physical injury requiring medical treatment, and therefore does not fall within Workman's Comp. The idea from the defense is that she has no remedy for a constitutionally protected cause of action. And according to, Article 1, Section 22 of the Florida Constitution, that can't be. And if I may, when we move on, there's language in the McKenzie case, which is cited in my brief, which says specifically that mental or nervous injuries caused by being held at gunpoint are not compensable under Chapter 440. The first, and I'm reading from the opinion, on page 2, the first sentence in Section 440.0931 provides a mental or nervous injury due to stress, fright, or excitement only is not an injury by accident arising out of employment. Examples might include a situation where an employee experiences mental trauma after being robbed at gunpoint, but does not suffer a physical injury requiring medical treatment. Although the legislature recognizes that such mental or nervous injury exists, they are not compensable pursuant to Chapter 440. So, the cases are, the courts are interpreting that the legislature understands that this is something that simply, they recognize this cause of action, but the legislature has decided that it's not compensable and not included in Chapter 440. In the Acton case, which was cited by appellants, a common law cause of action cannot be taken away without providing a reasonable alternative. This is again, the Supreme Court of Florida from 1983. And the language there, and they cite Kluger versus White, which is another Supreme Court case in 1973, where a right or access to the courts for redress for a particular injury has been provided by statutory law predating the adoption of the Declaration of Rights of the state of Florida. And this is the sentence that was left out by appellant's counsel, or where such right has become part of the common law of the state. The legislature is without power to abolish such a right without providing a reasonable alternative to protect the rights of the people of the state to redress for injuries, unless the legislature can show an overwhelming public necessity for the abolishment of such right, and no alternative method of meeting such public necessity can be shown. There's no such showing. There's no such attempt by the legislature to show that there's an overwhelming need to abolish this cause of action. So the legislature is without authority to do away with it. So anything that...
Well, counsel, let me, on that thought, the reasonable alternative issue.
Mm-hmm.
What the legislature does have, I perhaps would argue, or perhaps they would argue, the reasonable alternative here is they have preserved the cause of action. Negligent infliction of emotional distress still exists. The only difference now is that you have to have a physical injury requiring medical treatment. So that there is, some might say, oh, that's unreasonable, because sometimes you'll be injured, have a mental injury without a physical injury requiring medical treatment. So why isn't, the 440.0931, why isn't the statutory cause of action, why isn't that a reasonable alternative?
Why is that a reasonable alternative?
Why is the statutory cause of action that requires physical injury requiring medical treatment, why isn't that statutory cause of action a reasonable alternative for the common law claim of negligent infliction of emotional distress?
Because the negligent infliction of emotional distress, there is no physical injury requiring medical treatment. So I mean, they're two separate categories of injury. One is physical injury.
But it doesn't have to be perfect fit. What I read it to say is reasonable alternative means it doesn't have to be the same thing, but it has to be a reasonable alternative.
But,
And I'm asking, why is this unreasonable?
well, I'm just saying there is no, I mean, she has no alternative. There is.
I'm just giving you a statutory one. I'm asking you, why is that not reasonable?
I'm sorry, because there was no physical injury in her case.
Well, that's why they're different, but why is this one not a reasonable alternative?
Again, I'm having trouble following what you're
Okay,
saying, Your Honor.
go ahead, that's fine.
Our position is that workman's comp immunity only applies to cases that fall within workman's comp. It doesn't fall, if you were to file a claim against your employer for wrongful termination or age discrimination or sexual harassment, you don't have to file a workman's comp case first and have it denied. This is a totally separate cause of action. It's protected by the Constitution of the state of Florida and all the case law. That Willis case makes it very clear that it's a well-established cause of action under the common law of Florida. So our position is that Judge Jacobus's order denying their motion for summary judgment was correct, and it should be affirmed by this court. Thank you.
The Willis case is from 2007, and so while it might be that Ms. Spears would have a cause of action under the Willis case, the important question for the access to courts inquiry is what was the state of the law in 1968?
Is that the year the workers' comp system was adopted?
That was the year that the current version of the Florida Constitution was adopted, or I guess the main. Obviously, it gets amended from time to time, but that's what the case law says is the important year. I think the workers' compensation law existed before that, but so I mean you could look before that or you could look in 1968. But either way, the tort law did not provide a remedy for a person who sustained a psychological injury without.
So what's the best case that you can cite for the negligent infliction of emotional distress not existing at that time? In 1968?
I guess actually the Willis case, in Justice Quintero's dissent, he goes through a litany of cases showing that from 1985 up until the time of the Willis decision, the courts were requiring there to be a physical injury.
But you said 1985.
Did I say? I'm sorry. Let me just look at my brief here. I quoted it in a parenthetical. Just this. So I didn't identify like what's one specific case, but I pointed out that there's a litany of cases that were discussed by Justice Quintero in his dissent, showing over the course of many decades that there was no tort recovery for a psychological injury without an accompanying physical injury. In fact, I can point out this court's case in Davis from 1981, where the court said if you don't, at that point in time, if you did not have a cause of action in tort, you also didn't have one in workers' comp and vice versa. All because of the impact rule. And I would say, just back to Judge McIver's point about 440.093, that language, I just want to reiterate that it's important to look at the language of the statute and body of case law as a whole, which shows that workplace injuries are to be adjudicated in the workers' compensation forum when the issue is negligence. And I understand the Aguilera case talks about intentional torts, but I also want to point you back to 440.11 because 440.11 itself establishes that an intentional tort is an exception to workers' compensation immunity. So to the extent the Florida Supreme Court was just saying that there's an exception to that all liability language because of an intentional tort, that comes from the statute itself. But what 440.11 doesn't do is provide an exception for this situation when there's just a psychological injury unaccompanied by a physical injury as a result of the employer's alleged negligence. If there are no further questions, then I would just ask the court.
Well, I was expecting you to follow up on my question about reasonable alternative. Do you have any response to that line of thought? Like whether the statutory provision in this case?
Yes. Okay, thank you. I mean, I'm going to answer your question, but I wanted to reiterate that you
I thought
don't have to
your
have,
answer- I thought your answer would just be that, yeah, the statute provides a reasonable alternative, let's go home. No?
well, of course it does. Because remember, the workers' compensation law does not preclude recovery for psychological injuries. It requires a very minimal requirement that there also be a physical injury requiring medical treatment. That can be a very minor injury, as long as it occurs in the same incident and, you know, the psychological injuries are related to that physical injury. And so the case law says that, you know, tweaking the elements of the cause of action isn't diminishing it altogether. It's still providing a reasonable alternative. And that language is quoted in the brief from a Florida Supreme Court case, that just tweaking the elements of damages is not a denial of access to courts. And at most, that's what we have here, because the workers' compensation law does allow recovery for psychological injuries. It just sets the bar a little bit higher for what the employee has to prove in order to get those benefits. And I would just ask that you enforce 440.11 and not open the door to the courts for people who are less injured than what the workers' compensation law says is required to get an employer to pay compensation for negligence that causes an injury. Thank you.
All right, I thank both councils. We will be in recess.